Hello everyone, and welcome to our program for school board candidates. This program is going to cover the basics of school law for candidates. And joining me for this discussion is Susan Goldammer, MSBA staff attorney, and Mike Reed, Associate Executive Director for Advocacy for MSBA. And thanks a lot for joining us. We appreciate it. And Susan, let's start with you. One of the most probably fundamental laws that our candidates need to know about is what's commonly known as the Sunshine Law. What's that all about?
Well, this is a state statute that applies to all governmental entities, including school districts. It's also called the Open Meetings and Records Act, and it sets certain guidelines or rules for boards and committees created by or at the direction of the board. And in general, school districts must notify the public and allow them to attend school board meetings, work sessions of the school board, committee meetings, if they fit into the definition of the law. And in general, you have to allow the public to inspect and copy district records. Those are sort of the general rules.
And this may be a little different for a lot of our school board candidates who may come from the private sector. As a school board member, they are a public official, and most business has to be done in public, doesn't it?
It is sometimes difficult for new school board members to understand that you might have to have a conversation with the school board about a very sensitive or contentious issue in public, with the public watching the board discuss, and that's kind of difficult. There's only certain items that you can discuss in closed session, and there's a very narrow list of those items that can be discussed outside the public's eye. School board members also, for example, can't just show up at a school board meeting and say, I want this item put on the agenda, because we have to give the public notice of the items that we're going to be discussing. And so this does put a little bit of constraint on school board members, and it is real important that they understand this law, because they can actually be sued as an individual for violating this particular law. There's not very many laws where that occurs, but this is one of them.
And as far as the mechanics of making sure a meeting is posted properly, that sort of thing, that's usually done by the school district's administration working with the board. Is that right?
That's correct. Usually the superintendent or the board secretary or the superintendent secretary will handle the posting issues. The important thing for school board members to understand is if you have an item that you want to bring up at a meeting, you have to let them know ahead of time so that they can make the mandated posting requirements.
I know one of the issues related to this, Susan, is actually what constitutes a meeting of the school board, and that can be problematic sometimes. If an informal gathering of board members sometimes could be a public meeting, couldn't it?
If there is an intent to violate the Sunshine Law, or quite honestly, any discussion of public business by 4 or more members of the board could be a meeting that needs to be posted, and if the board isn't posting it, it could be a violation of the law. We're finding more and more problems with school board members inadvertently violating the law because they are emailing each other, emailing the entire board or texting the entire board and having discussions of public business without posting this discussion as a meeting and giving the public the opportunity to attend.
Now, Susan, you said there are some exceptions. There are some times when business can be discussed in closed session. What are some of those?
Well, let me just give you an example. The list there's several of them, but it has to fit into one of these categories in order for the board to be able to discuss the item in closed session, or in order for the district to keep that record closed and confidential. So, for example, discussion on hiring, firing, disciplining, or promoting employees can be done in closed session, although any final decisions on that does become available to the public after 72 hours. Personnel records like applications or evaluations are closed. Discipline records of identifiable students are closed and not available to the public. Discussions about legal actions or potential legal actions are closed until the issue is finally resolved, which sometimes can be years if we're talking about a lawsuit. Lease or purchase or sale of real estate can be discussed in closed session if public knowledge of the transaction might impact the price. So if the price might go up, if the public knew that this was in discussion. Emergency plans, security systems, structural plans of buildings, all of that, we can keep closed to prevent a terrorist attack and to keep our schools safe. And then there's always these catch-alls, records which are protected from disclosure by law, because there are some other laws that require the school district to keep information closed and confidential.
So Susan, what happens if a board violates the Sunshine Law?
Well, as I mentioned previously, individual board members can be sued. The board as a whole can be sued. There can be fines depending on the factual circumstances. The district or the individual might have to pay attorney's fees. And the court can order either reversal of decisions, or the court can order board members to stop violating the law. And of course, if you violate a court order, there's some serious consequences as well, but I'm sure none of my districts would do that.
And there are some public relations consequences too, aren't there? I mean, a board doesn't want to see that headline in the newspaper that board meets in illegal closed session.
Exactly. In fact, the PR is actually in many respects even more important than the law. Public perception is very important. The reason the Sunshine Law exists is to create transparency with the government. Taxpayers get to see what you are doing and how you are doing it. And if there is a perception that business is done behind closed doors and everything is secretive, there is at least a perception that corruption is involved. And we, of course, don't want that perception associated at all with public schools. And so it is difficult sometimes for school board members to understand the law and completely comply with the law, but you will receive, if you are elected, a lot of training on the Sunshine Law, and the Sunshine Law is very important.
Mike Reed, let's talk about the issue of nepotism, and that comes up once in a while, doesn't it, related to school board?
Nepotism does come up every once in a while, and what is nepotism? Nepotism is hiring your family, but it's even more important than that, because it's part of the Constitution of the state of Missouri. Article 7, Section 6 of the Constitution of Missouri says school board members cannot vote to employ their relatives in any matter, be that as a contract employee or just whether they're appointed to an office without compensation. So within the fourth degree of consanguinity or affinity, which means blood or marriage, and it goes out to first cousins. So it's a very important situation to understand that this part of the law is extremely important, because you can lose your position if you violate the nepotism clause of the Constitution. Board members should be very, very aware of this. When I was working for the Ethics Commission, one of the complaints that we had came from a school board member. First meeting, and there was a consent agenda, and the consent agenda allowed for the rehiring of certain individuals to do work with the district. So there were teachers doing extra work, sponsorship of clubs, et cetera, et cetera. And one of this board member's relatives within the fourth degree was hired. The person voted on it. It was a consent. Everybody said yes, and they lost their position. So you have to be very careful about hiring and firing, and looking about when those things happen, when consent agendas come up about hiring, firing, again, for positions even that don't have any monetary value.
Now, Mike, but the law does not prevent spouses from being employed by the school district. I mean, that's fairly common in the state where we have board members with spouses as teachers.
It is. And what happens at that point in time is the spouse, if for the employment, voting on the employment, leaves the room and abstains, and puts in the record that they are abstaining from voting.
Mm-hmm. So the person can be hired, it's just the board member cannot vote on that.
That is correct. The person can be hired. You cannot vote, do some sort of overt action to put your family member into an appointed position or a hired position. That is correct.
Another question that comes up often, Mike, is board members voting on salary schedules when a spouse may be a teacher and may be benefiting from a salary schedule. How does that work?
And that's on the conflict of interest law, and I think Susan's going to talk about that in a few minutes. But that comes about when it happens that you cannot vote on something that gives yourself or your spouse something that is greater than everyone else in the same category. So if in fact it's a salary schedule and everyone is treated exactly the same, you actually can vote on it. But if your spouse is the only person in that category, then they're treated a little differently than everyone else. So you have to make sure that what you're voting on, the person, the relative, is not treated any differently than everyone else who's in the same category, in the same group.
So is the safe thing to do, Mike, to abstain if there's any question at all about nepotism?
Safe thing to do is to abstain, yes. And a safe thing to do if there's a chance of a conflict is to abstain. Certainly you always can, and it's better to be safe than sorry.
Mm-hmm. Conflict of interest, Susan, tell us about that and its possible impact on school board members.
Their conflict of interest laws are quite many and broad. We don't have enough time today to cover absolutely every conflict of interest law there is in the statutes, but there's one in particular that I think candidates really need to know. Board members can't be employed by the school district, but the school district can do business as sort of an independent contractor with a board member or businesses that the board member owns or their family owns, etc. However, if the business exceeds $500 per transaction or $5,000 per year, the business must be publicly bid. The transaction must be publicly bid, and the board member's business must submit the lowest bid in order for the school district to continue doing business with that business entity. This is important because board candidates frequently own businesses in the community, and those businesses have transactions with the school district, and it's important for board candidates to know if they are in that position. There might be some limitations, and in fact, their being a board member might limit what kinds of business the district can do with their business. Mm-hmm. And in fact, the law talks about, businesses owned by the board member and associated with. And let me just go through on the slide a couple of these things so that the board candidates know what we're talking about. This applies to transactions between the school district and the board member and businesses owned by a board member. Transactions with the board member's spouse and businesses owned by the spouse. Transactions with the board member's dependent children and businesses owned by their dependent children. A partnership or joint venture in which a board member or his or her spouse is a partner other than a limited partnership. A corporation or limited partnership in which the board member is an officer or director. And that would be even if they're not an employee, if they are just on the board of directors of the corporation. A corporation or limited partnership in which the board member or his or her spouse or dependent child owns more than 10% of any class of stock in the partnership units, and any trust in which the board member or employee is a trustee or settler, in which the board member or employee's spouse or dependent child is a beneficiary. So this is pretty detailed language, but I do think it's important for our candidates to know what businesses will need to, if the transaction exceeds $500 or all of the business done in a calendar year might exceed $5,000, the district's going to have to bid it out. And if the board member wants the bid, their business or the businesses they're associated with have to be the lowest.
Mm-hmm. So, Susan, if a board member is concerned about a potential conflict of interest, is it a good idea to consult legal advice before proceeding on it?
It is. And if the board member, I tell board members it's real important at this point in time to figure out, does you or your family own businesses that have transactions with the school district, and what amount of those transactions in the past years? And we need to disclose this to the school district so that the school district is able to work with the board member to make sure that they're bidding when they're required to be bidding.
Okay, so we've covered only a few of the many legal issues that relate to school board service. And Susan, as you mentioned, once our candidates are elected to the school board through our training, we'll get into much more detail on legal issues, won't we?
Absolutely.
Yeah. All right, Susan Goldammer, Mike Reed, thanks a lot for being with us on this segment on legal issues for school board candidates.